All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Morning, counsel. How are you today? Let me call your case. This is CV15 375 AA Builders Limited versus Preferred Contractors Insurance Company, LLC. This is the time set for oral argument. And for appellant, I have Ms. Freeman and Mr. Willits for appellee.
That's right, with Nelson Nixon.
All right, thank you, counsel. As you know, we've read the briefs. We're familiar with the issues in the case, so keep that in mind as you make your presentation. You both have 20 minutes. Ms. Freeman, if you want to reserve some time for rebuttal, let us know when you step up to the podium. I also want to let you know that the proceedings are being recorded and uploaded to our website, so there will be an audio and visual recording on the Court of Appeals Division 1 website of this argument. I'd like you to be aware of that fact. With that being said, Ms. Freeman, your argument.
May it please the Court, my name is Allison Freeman. I'm here on behalf of the law firm of Broning, Oberg, Woods & Wilson, representing Preferred Contractors Insurance Company, the appellants in this case. The Superior Court in this case made legal error in three basic ways. The first is by ignoring this court's rulings as it relates to whether a commercial general liability policy covers faulty work from a contractor. In finding that in this case the damages claimed for faulty work were covered by a commercial general insurance policy, this court ignored. The Superior Court ignored this court's rulings as they've been affirmed 3 separate times. Secondly, the your work exclusion in the insurance policy at issue clearly by its terms does not provide coverage for the claims asserted. The Superior Court ignored that language and did not interpret it correctly. That would be legal error number 2. Finally, the Superior Court decided that despite the only damages being claimed in this case being for repair to faulty work, the court decided that those were preventative measures and read the Desert Mountain case incorrectly to find that they would be covered by the commercial general liability policy. To start out, we look at the advanced roofing case. The case this court decided in 1989. And that court, this court, clearly held in that case that faulty workmanship standing alone cannot constitute an occurrence under a commercial general liability policy. Secondly, the court stated, nor would the cost of repairing the defect constitute property damage. In this case, the appellee is AA Builders. The only damages being claimed under the preferred contractor's insurance contract are for the repair to faulty work. The only costs being claimed are the costs to replace the defective roof, nothing more. There are references throughout the briefing to damages to this movie theater at issue. There is references to leaking that went into the individual viewing rooms. There's references to saturation of the lightweight concrete that caused crumbling. There's references to rusting. None of those damages are being claimed in this case. And as a result, this case is the same as advanced roofing. Even in advanced roofing, the facts there were that the roofing contractor repaired some of the roofs it was supposed to, and the roofs that it did repair, it did a faulty job of repairing. There was evidence in advanced roofing that, in the form of responses to interrogatories, that stated there was leaking in the homeowner's roofs, and there was damage as a result of those leaks. But those damages were not claimed in advanced roofing, just as they are not being claimed in this case. As a result, the facts are parallel, and advanced roofing controls and requires this court to rule that there's been no property damage caused by an occurrence and therefore no coverage under the preferred policy.
I'm always a little nervous about judicial decisions that tell us what insurance policies generally mean. I think we tend to get ourselves in trouble when we when we just broadly declare what insurance policy means. So let's look at the language of this policy. Does your position depend on the notion that there is a difference in the coverage afforded to named insureds and additional insureds?
Only as it relates to the your work exclusion. And it's not that the coverage is different. It's that the your work exclusion specifically defines your work as work performed by the named insured.
Right. So an additional insured can't, for your position to hold, an additional insured and a named insured can't really stand in each other's shoes for those purposes. An additional insured is a lesser being.
No, Your Honor, I wouldn't say it that way. The additional insured is entitled to the coverages provided by the policy. The coverages provided by the policy as it relates to the your work exclusion in this case, the your work exclusion excludes coverage performed by the named insured. It excludes coverage claimed by Anchor Roofing, the named insured, arising out of the work of the named insured Anchor Roofing. It excludes coverage to the additional insured, AA, for work arising out of the work of the named insured Anchor Roofing. So as that is going to get argued by AA in this case, the argument presented is not, they've admitted in their briefing that the your work exclusion applies to exclude the work performed, the faulty work performed by Anchor Roofing. They have agreed to that. What they're saying is the subcontractor exception to that exclusion should reinstate coverage for AA, even though it would not reinstate coverage for Anchor Roofing under these circumstances, and that's where they are in error. Because the subcontractor exclusion specifically says if you, the named insured, Anchor Roofing, hires a subcontractor, then the exclusion for your work is not going to apply. The subcontractor exception applies. AA has their own insurance policy, their own commercial general liability insurance policy with Westford, who was a defendant in this case. And that policy also contains a your work exclusion and a subcontractor exception. AA can make the claim, as they did under that policy, to say, well, I know this was my work as the general contractor, but the subcontractor exception in my CGL policy as AA applies here, and it doesn't exclude coverage. That's the benefit under the policy that they purchased. By being added as an additional insured under the Anchor Roofing policy, it does not expand coverage, as they are arguing.
In fact, is there any premium for adding an additional insured?
There is not, Your Honor. Moving on from the advanced roofing holding to Lennar. It's the next case where the court again affirmed that faulty work standing alone is not covered by a commercial general liability policy. Lennar distinguished that and said, well, in this case, it was a soils case, faulty soils case. In this case, the court stated, we have cracking walls, we have cracking grout, we have cracking tile. Those are the occurrences in the property damage that could be covered under the commercial general liability policy. And that's why Lennar said, this case is different than the advanced roofing case. And this case, the insurance carrier should have stepped up and defended when they tendered the defense. That's not our case. Our case is very different than that. Our case does not claim any damages for the water that infiltrated the movie theater, for the rusting, for the water that infiltrated the cement, for the crumbling of cement. Those damages are not claimed in this case, and that makes this case different from Lennar. The next case in the chain of cases discussing advanced roofing is the Desert Mountain case. The Desert Mountain case specifically held in 2010, decided by this court, that Liberty Mutual, that repair of the defective workmanship is not covered by the Liberty Mutual policy. Even in the Desert Mountain case, still, they cite to, as the authority, the advanced roofing case. And they say faulty workmanship alone is not covered by CGL policies, and the cost to repair it is not property damage caused by an occurrence that is covered by these policies. There has been no change to this case law since 1989. The facts are parallel in this case to advanced roofing. You will hear AA argue that there's been a change in other jurisdictions, that they're reading the insurance policies different now. I would refer this court to the reasoning in 1989 when advanced roofing was originally decided. In that decision, this court said that there are other states that disagree, that find that faulty workmanship can be covered by a CGL policy. And the the advanced roofing decision says, in our opinion, these authorities disregard the fundamental nature of a comprehensive general liability policy. They ignore the policy requirements that an occurrence be an accident. If the policy is construed as protecting a contractor against mere faulty or defective workmanship, the insurer becomes a guarantor of the insured's performance of the contract, and the policy takes on the attributes of a performance bond. We find these authorities unpersuasive.
Which case were you citing there?
Again, that's the advanced roofing case.
Okay.
The one that was decided in 1989. The same. There was other courts or other cases, other jurisdiction that disagreed back then, and that's where the court came. And really, what it comes down to is faulty workmanship is not an occurrence. It's not an accident. And that's where there are a lot of extra-jurisdictional cases that we have cited in our briefing.
I apologize. I wasn't even born in 1989, so. Okay.
Luckily, I was, but barely.
Born in 1990.
The year work exclusion. A completely separate basis to reverse the Superior Court in this case. The first basis is that these CGL policies do not cover faulty work. The second basis is the year work exclusion and the preferred policy applies to bar coverage for the damages claimed by AA. The year work exclusion, the plaintiffs have agreed that the exclusion does require damage to work other than that performed by the named insured for coverage to apply, for the exclusion not to apply. So we agree the exclusion applies and negates coverage in this case. Where AA disagrees is they are arguing the subcontractor exception to the your work exclusion reinstates coverage. And as briefly touched upon before, they are making the argument that AA is also a named insured under the policy because that is the only way for this policy language to be interpreted to find that there is some coverage for the work done by Anchor Roofing. That interpretation is contrary to the policy language, contrary to the endorsements, and contrary to the common sense of how these policies work. They also argue the separation of insureds issue. That doesn't apply here. We're talking about policy language that specifically says if the work arises out of what the named insured's done, it's not covered. The only exception is if the named insured, Anchor Roofing, hires a subcontractor, and that did not happen here. If we take the plaintiff's argument, AA's argument, to its end about arguing they are a named insured under the policy, that would open up coverage under the Anchor Roofing policy to liability for AA for every other subcontractor that they could potentially be liable for. That's certainly not the intention of the parties. It's not what the endorsements accomplish. It's not what the certificates say that add them as an additional insured to this policy.
Did they ever raise, like, the property damage to completed work coverage provisions at all?
The property, no, Your Honor, the your work exclusion has been the focus of this, and the your work exclusion is limited to completed operations. It does not apply to ongoing operations per the terms of the policy. I'm going to go for about 2 more minutes, and then I would like to reserve 5 for rebuttal. The last issue is the finding by the Superior Court that Desert Mountain Properties versus Liberty Mutual somehow supports a finding that the cost spent to repair the faulty work of Anchor Roofing is a preventative measure and therefore should be covered by the commercial general liability policy. That is not what the policy says. That is not what Desert Mountain Properties said. As I said before, the Desert Mountain case specifically said we're not covering the expense for repair of faulty work. And they didn't, and the court found that that would not be something they would be awarding as damages. What Desert Mountain did that was peculiar was there was damage to other property in the Desert Mountain case. Some walls were falling down. And what the contractor did was, instead of straightening the wall back up, which would be repair to non-defective work, covered damage under a policy, they repaired the soils, they put things in place to prevent it from falling more. So preventing the non-defective property from falling more, they found that was going to be covered under the policy. They specifically state, and this court specifically stated in that case, the peculiar nature of the repairs Desert Mountain performed makes it difficult to apply the strict rule that the insurance carrier was arguing for. Again and again in that case, it says, under these circumstances, Desert Mountain did not aim to return the wall to its original position prior to the soil settlement. Instead, its goal was to ensure that the wall would not move further out of place. So what the court is saying, if the contractor had incurred the expense to put the wall back up, that would be covered because it's repairing non-defective work. So the fact that they had to take additional measures to make sure that wall didn't fall more, we're going to call it covered on the policy. Again, the soil cases are very different. They involve every aspect of the home. Repairing soils is very different. Here, there's a replacement of a faulty roof, and it's not covered by the policy. I'll reserve the rest of my time for rebuttal. Thank you.
All right, thank you, counsel. Mr. Willits, your argument?
Thank you, Your Honor. Good morning. I'm Barry Willits on behalf of AA Limited, the appellee. Your Honor expressed some caution about making judicial proclamations on what CGL policies mean and should mean. And if there's one constant in the Arizona cases on insurance, it's that the policy language governs the scope of the coverage. So I'd just like to jump right in to the policy language. This policy, like
Can I ask you one question first, though? Just to clarify a factual matter, you're only seeking recovery for the cost of replacing the roof, right?
I'm only seeking recovery for the cost of repairing the property damage, Your Honor.
Well,
which is the membrane.
We can get into those definitional issues in a moment. But is there some property damage you're seeking to recover other than the roof?
The roof membranes only, Your Honor.
Okay, thank you. Go ahead.
Okay, so we have two parts of this policy. On the one, we have an insuring clause, we have exceptions or exclusions. The insuring clause sets the universe of claims that are potentially covered. The exclusions then reach out and bring them back. They claw them back and put them out of coverage. Starting with the insuring clause, occurrence. It's simply an accident, including the repeated exposure to a harmful condition. In Lennar, the court held that defective work of a subcontractor was accidental if the harm was not intended by the insured. The insured there was a developer general contractor. The work was done by a subcontractor. The analysis of the court was very simple and plain. Did the general contractor intend for the shoddy work of its subcontractor to result in harm? There was no evidence.
How is that in any way relevant here? What we have here, I think, is an agreement between the parties that the CGL policy doesn't cover the named insurer's defective work, right? In Lennar, it was a subcontractor, but here, it's not.
I'm not following you why this is. The work here was performed by a subcontractor, Your Honor, by Anchor Roofing, not by my client, AA.
Okay, but not by the named insured under the policy. I mean, it was performed by the named insured under the policy.
It was performed by one of the named insureds under the policy.
How many named insureds were there?
Well, Your Honor, the definition of named insured is the named insured and anyone qualifying as a named insured.
So, in other words, additional insureds.
Additional insureds. Under the three additional insured endorsements, AA became the named insured for purposes of AA's claims against that policy. AA is the only insured under that policy as far as a claim by AA is concerned.
So that's really kind of where the nub of this case is. I asked your colleague the same question. Your position depends on treating named insureds and additional insureds exactly the same for all purposes.
Not for all purposes, for purposes of the your work exclusion. The your work exclusion says, assuming it's covered under the insuring clause, we will not provide coverage for property damage to your work or work on your behalf. Mm-hmm. Okay, so property damage to your work. Who's the your?
But in this context, then, that transforms an additional insured for whom no extra premium is paid into somebody who has effectively more coverage than the named insured.
It has the same coverage because the language is the same. Let me put it this way. Please give me a running start, and then I'll circle back around. So a small general contractor like AA, it's not running out and buying project-specific, exotic-type insurance vehicles. It puts in its subcontract, which is in the record here. Every sub, you have to obtain and maintain your own CGL insurance, and you have to name us and add us as an additional insured to cover liabilities imputed to AA arising out of that subcontractor's work. That's the purpose of these AIs. The AI fits seamlessly, but the subcontractor exception that was added to the your work exclusion in 1986. Prior to 1986, your work meant AA's work and anyone working on behalf of AA. The subcontractor exception then reinstated coverage for property damage to work performed by the subcontractor. That's exactly what we have here. So now, you teed up your question. Who's you? Who's the subcontractor? The subcontractor is AA. I'm sorry, is Anchor Roofing, the roofing subcontractor. The you is AA. The separations, for two reasons. Separation of insureds clause says you have to treat, when you read the policy, I mean, it's confusing when you have all these multiple insureds. You have to read the policy as if the claimant is the only insured under the policy. If AA is the only insured, then the only subcontractor that can be referred to is AA's subcontractor, not AA's subcontractor. Why would all these general contractors be in the business of requiring their subs to provide insurance that only covers property damage arising out of their sub-subs work? That doesn't really help the general contractor. That's a very rare circumstance that the work is brokered that way.
Why do general contractors ever buy insurance?
Why do general contractors buy insurance?
Yeah, because under your reasoning, they're completely covered by the subs policies.
I'm not saying they're completely covered by they're only covered for occurrences that result in property damage that aren't otherwise excluded.
But here, the only property damage at issue in the case is the faulty work,
which resulted in property damage.
But which is not at issue in the case, right? That's why the very first question I asked you, you said you were suing for the property damage, but the question I really asked you was whether you were suing for anything other than the repair of the faulty work. And I think you acknowledged that you're only suing for the cost of repairing the faulty work.
I am suing for there's nothing in the policy, Your Honor. There's no language in the policy, unlike in Desert Mountain, which had a faulty workmanship exclusion. There's nothing in the policy that requires us to analyze faulty work. Faulty work has no standing as under this policy one way or the other. What the policy covers is an unintentional harm that results in property damage. Doesn't meet those definitions. If it does, then we meet the insuring clause.
If you're suing for property damage.
Well, let's talk about property damage. The definition of property damage is physical injury to tangible property. Cracks to the membranes that we replaced. Cracks is a physical injury. The membranes are tangible property. How does that not meet the property damage requirement? There's nothing in property damage that requires that there be, like she suggested, damage to property other than the defective work. There's nothing in that definition. There's nothing in the definition of occurrence that suggests that. Even in Lennar, there were different types of defects. There was the soil defect, which resulted in other damage, but there was also drywall, framing, backing defects that allowed the drywall and the baseboards to pop off. And the court specifically quoted the expert who said a lot of this stuff would have happened independent of the soils. And there's no parsing in Lennar about, well, the resulting damage to other property is covered, but the property damage that just is defective work itself is not covered. If it meets the definition of the insuring clause, it's covered unless it's excluded by the your work exclusion. The cases we cite, there's 6 or 8 recent state Supreme Court decisions from other states that go at great length, and they take on all these issues. And they have all of this in common. They look at the policy language. All of them followed the Lennar test for what an occurrence is. I concede to you, there are a lot of states out there that don't follow Lennar. Defective work cannot be an occurrence. It's a public policy decision that they made. We are not one of those states. In these cases, Lamar Homes out of Texas, Sheehan out of Indiana, Charrington out of West Virginia, in all these cases, they actually look at, well, does the property damage need to be to non-defective work? No, they say, because look at the definition of property damage. There's no distinction between other work, non-defective work. There just needs to be physical injury to tangible property. What these courts do say is when you do get hung up on which property got damaged, it's generally because those courts have read into the insuring clause the notion of the your work exclusion.
Which sort of goes to the evil I mentioned at the beginning of courts taking it upon themselves to define the scope of insurance policies. These are private contracts with words that we can read. So why don't we focus on the language of the your work exclusion and go through that together.
Okay, thank you, Your Honor. I agree with you. So, the your work exclusion. I'm looking at the policy that's in index of record number 62, Exhibit H, with the serial number PCIC 000096. So there's exclusion L, damage to your work. It excludes, quote, property damage to your work arising out of it or any part of it and included in the product's completed operation hazard. So, if this were pre-1986, before the subcontractor exception, there's no coverage here because the property damage was to the membranes. The membranes is our work. But this exclusion does not apply if the damaged work or the work out of which the damage arises was performed on your behalf by a subcontractor. It meets that. We're right there. Yes, this work, the damaged work, the only work that we paid to repair, the cracked, rotting membranes, was performed on our behalf by a subcontractor.
Okay. So then we come down to the definition of the word your. Right?
We do, Your Honor. Okay, so under the your work exclusion, let's talk about your. Again, somebody has to tell me what the purpose of the separation of insureds clause if it doesn't apply here. We've cited cases, including additional insured cases, where they're saying when you have multiple insureds, it's confusing. This is to eliminate the confusion. Treat the insured as if it's the only insured. If the only insured is AA, then the only subcontractor can be AA's insured. That's why this subcontractor exception reinstates the coverage that was provided by the insuring clause. Also, again, the you is defined as a named insured or anyone qualifying as a named insured. There's 3 different additional insured endorsements that were issued that have the combined effect of qualifying AA as a named insured. We have a blanket AI endorsement that was issued with the policy right off the bat that says anyone added to the schedule is a member. If you look at the front, the declarations page, the named insured is member. Then we have 2 other additional insured endorsements that were issued specific to AA that said AA is added to the schedule. So AA is added to the schedule. Anyone added to the schedule is a member is a named insured. That's how we get there.
That's how we get to your view that for all purposes, named and additional are simply the same.
What you usually see, Your Honor, is the additional insured endorsement itself will contain, sometimes you'll see them now that they're 8 pages long, and they will contain the conditions under which the additional insured is being.
We have some of those in this case, right? I mean, we have some descriptions of the coverage afforded to an additional insured in this policy.
We have these are as broad additional insured endorsements as you're going to find. You don't find these on the street anymore, and if you did, you'd have to pay extra for them.
But with no disrespect to all those other policies, in keeping with our philosophical agreement at the outset of your argument, do we care what they say? Don't we just care what the language of this policy says?
No, I agree with you, Your Honor, and I'm just saying these are very broad AI endorsements. That these endorsements don't include what you normally see as far as reducing the coverage. For example, a very common endorsement right now is an endorsement that for AIs deletes the subcontractor exception. It deletes it. We don't have this issue. We know, the general contractor, we know we don't have coverage arising out of the sub's work. That's not the kind of exclusion we're talking about. We don't have that here today. Now, let me just kind of move on to the preventative measures, because this might be a way to short circuit all of this, Your Honor. Let's just say I can't convince you we're the you. This would put us in the exact same position as Desert Mountain in the Desert Mountain case. Desert Mountain had a faulty workmanship exclusion. No coverage. Coverage is excluded for repairs arising out of faulty workmanship by you or on your behalf. Okay? That's essentially the equivalent of the your work exclusion without the subcontractor exception. Yet in that case, there was still coverage if the repair of the faulty work had another purpose. The purpose there was to prevent property damage to other non-defective property. That's what we're doing here.
Do we have that in this policy language?
We do not have a faulty work exclusion, Your Honor. Our policy is actually broader.
But when we talk about the purpose of the repair, I mean, that's nowhere mentioned in the policy that I saw.
The purpose of the repair, no, nor was it in Desert Mountain. The purpose, that's a good point. The policy language is not concerned with the purpose. The policy language is not concerned, unless it's under your work, with which work. It's only concerned with, was it unintentional? Did it result in property damage? And was there a subcontractor exception if it was performed by a sub? That's what our policy is concerned with. But I just pointed out, to go through the exercise, Your Honor, that even if we say, you're not the your work, well, now we're in the same boat as Desert Mountain. Desert Mountain had a faulty workmanship exclusion for work done by it. And yet there was still coverage to prevent property damage, there was coverage to stabilize those defectively compacted soils to prevent movement of the retaining walls. Why would repairs to defective work necessary to prevent a roof from ultimately collapsing, which is not challenged in the record, not also be covered? And again, Desert Mountain has a much more narrow policy, unless you read the your work exception the way they ask you to. So I think we have an occurrence. It's unintentional. We have cracks to tangible physical property. So either the separation insureds clause means the subcontractor is our subcontractor, or we qualify as a named insured through that circular route I gave you, or they're right, and then your work exclusion boxes us out. But we're performing work to prevent property damage to non-defective work. Now, if you look at the cases, Your Honor, and I apologize to your clerks because there's tons of them, and they're long. And they basically fall down to 4 categories. You have the non-Lennar cases, the cases they cite that just says public policy, defective work isn't covered, people. It's not an occurrence. It's not property damage. You got to have other property. That's not our state. We're a Lennar state. Is it unintentional? Does it result in property damage? That's what triggers the insuring clause. But most of the cases involve claims by insureds who perform their own work. There's a lot more subcontractors than there are general contractors. And most of these cases that require property damage to other work, advanced roofing, subcontractor. If it's by the party who performed the work, by the sub, it's already excluded. The subcontractor exception doesn't apply. That's why those cases come out that way. They're rightly decided. I did want to address, in advanced roofing, I believe Allison said that there was leaking. There was no leaking. That insurer just said, hey, we allege defective work, and they wanted coverage. That's not enough. They had alleged property damage. Never has something so true as the statement property damage or defective work standing alone is not covered. It's so true, but it creates a lot of mischief because people read into it 2 different things. Some people say, well, that means you got to have damage to other property. And other people, like in Lennar, and they say this twice, including in the heading, says, no, you have to have property, or the defective work has to result in damage to property, not to other property. But regardless, even if it has to be to other property because of your work exclusion doesn't apply, we prevented damage.
It almost seems like your construction of property damage would swallow the workmanship exception because everything would be property damage and nothing would constitute the workmanship of the particular subcontractor.
Thank you, Your Honor. Subcontractor walks off the job, won't finish his work intentionally. That's an intentional act. It's not an accident. It's not covered by CGL policy. That's a performance bond. That's painting subcontractor. Paints my wife's house, not Navajo white, but flaxen. Big problem.
You bet. That'd be a big problem if you did it in my house.
But no coverage. There's no property damage there. What we have here, though, are cracks, soaking, structure getting weakened. We've replaced the cracked, defective work so that the roof doesn't collapse.
Okay. Anything else? Sorry, Counsel.
No, thank you,
answer
Your
that
Honor.
question. All right, Ms. Freeman?
I guess starting out by addressing the issue with the advanced roofing case, it does state in that case on page 479, in answers to interrogatories, there's suggestions that there was water damage to some of the homeowner's property. It was at issue in this case, but again, not claimed as damages, just as in our case. Addressing that we are a Lennar state, yes, we are a Lennar state, and the Lennar court held that the cracks to the walls, the cracks to the tile, the separation of the grout caused by defective soils was an occurrence that could be covered under these policies. That was an issue where the court was looking at, did the insurance carriers correctly deny a defense to Lennar? And the court said, this court said, no, because the allegations of cracks to walls, cracks to grout, separation of things in these houses as a result of faulty soils constitutes an occurrence. And therefore, we're going to remand, and the court needs to decide what damages are covered by that policy. Lennar never reached the issue of whether faulty work was a damage covered by the policy. They simply held, hey, this triggers a duty to defend, and you need to go back and look at all this. Lennar again says under advanced roofing, faulty work alone is not covered by these policies. And it does go back to the language of the policies because an occurrence requires an accident. And faulty work is not an accident. The obligation to repair defective work is neither unexpected nor unforeseen. Unexpected property damage to otherwise non-defective property of the work, that's a different situation. And that's how it plays back into the policy language. Addressing the issue with Desert Mountain did not rely on policy language for its policy language different than what we have in this case to find there is no coverage for repair of defective soil that was faulty work. And that was a finding from the trial court, and this court upheld it. They relied on advanced roofing for that finding. No one is added to this policy as a member, other than Anchor Roofing. Anchor Roofing is the named insured. They're the only defined member. There is an endorsement. Yes, John?
The additional insured is sometimes treated as a member under the policy language.
Actually, not in the way this policy is written. The additional insured is added as an insured and is added to the definitions of insured under the policy, but not to the definitions of you. The definitions of you are only the member and only Anchor Roofing. And you'll see the easiest place to find this is actually attached to the briefing provided by AA. They attach the endorsements, the certificates that they received that add them as the additional insured, and then they attach an endorsement that it did appear in the Anchor Roofing policy, and it says, if you want to add members to this policy, list them here in this endorsement, and here's what the coverages will be that apply.
My only point is that in some circumstances, the policy language does say additional insured receives coverage as if it was a member, right? I mean, so there are times we have to look at when the additional insured is treated as a member.
Only if it was added pursuant to the endorsement that specifically says whoever appears in this schedule is also going to be treated as a member in this policy. And that schedule is blank. And that schedule never added anyone besides Anchor Roofing. AA was added pursuant to certificates issued that said you're going to be an additional insured under this policy and you're going to be treated as under the definition of insured, not under the definition of named insured. Final issue. This court can reverse the Superior Court because there's no coverage for faulty work. It can reverse the Superior Court because the your work exclusion excludes the damages at issue in this case. There are two independent bases to find that ruling. And nothing in the Desert Mountain case provides coverage and changes the advanced roofing rules. Thank you.
Thank you both, counsel. We'll take this matter under advisement and issue a written decision in due course. We're in recess.